let's shoot forward and move through fairly quickly some of the employment issues that we need to understand as we talk about the potential for marijuana legalization. The first one is, where will we find employees? Those of you particularly who may have operations in the eastern part of the state are very familiar with the level of activity that was promised by bringing the shale industry and the fracking industry into Ohio. This is going to be a boom. We're going to have all this employment in a part of the state that's very depressed. Unfortunately, in Mahoning and Trumbull counties, the statistics show that 80 to 90% of all applicants for all of these good-paying jobs were not able to pass initial drug tests. And so the jobs that we were hoping would go to people from Ohio ended up being given to people who had to be imported in who could pass drug tests. The national average for entities that have that are subjected to federally mandated drug testing programs, the fail rate is 3 to 4%. So we had a 20-fold increase over that. Issue number 2. This is a very tragic case that highlights well what is likely to happen in the courts when we talk about legalization of marijuana. So in this instance, the young man named Brendan Coates was 16 years old. He was involved in a very severe car accident in Colorado, and he was left quadriplegic. And as a result, he had a lot of not only pain, but also societal concerns, interacting with people, being concerned about his appearance and so forth. So he used medical marijuana at night, and he says he never got high at work, he never used at work. He was tested at his job in 2009, and he tested positive and was terminated as a result of the company's policy. He brought a lawsuit in 2013, which worked its way up to the Supreme Court in 2014. His argument was Colorado has what's called a lawful substances law, meaning if you engage in some lawful behavior outside of work or anywhere, you should be protected by that. And his point was, I engaged in lawful behavior, you terminated me in violation of my right to exercise that legal right in Colorado. The Supreme Court just came back this summer and said, too bad, you engaged in lawful behavior under Colorado law, but not under federal law, so you lose. And this case got a lot of coverage in the media, but I suspect that other states would take the same position if dealt that same deck of cards. Similarly, we've had a number of cases come out in the area of whether employers will have to accommodate employees who have any sort of a medical marijuana prescription. And in this case, which came out of Colorado, the court decided that Oregon law prescribes that it be construed, the ADA, be construed consistently with any similar provisions of the ADA, the ADA, Americans with Disabilities Act. The act does not permit the use of marijuana because marijuana is an illegal drug under federal law. So again, this reliance on federal over state law, which at some point could be challenged, but at this point, this is the state of the law that we have. One thing to note, in issue 3, which is the measure that was just defeated in Ohio, there was an express provision in it that said that a patient who has a medical marijuana certification may self-administer the medical marijuana if the employer allows other people to self-administer for whatever medication they're using. So this is a bit of a learning tool for all of you. Take a look at your substance abuse policies, understand and know what kinds of limitations you want or can impose on individuals who may be using legal products, prescriptions. Now, I suspect that this statistic came out of primarily states where medical marijuana is already in play. 4% of the employers who were surveyed by Higher Right indicated that they have adjusted their policies to accommodate for medical marijuana use in the workplace, and that another 6% plan on doing so at some point soon. So about 10% of employers are accommodating for medical marijuana. But as we'll see in a minute, that's not necessarily needed. Okay, another challenge that employers are going to face, unemployment. It's an indirect cost, but it's a cost nonetheless to employers. We have some guidance out of Michigan where medical marijuana is legal, and the court in that jurisdiction said it's perfectly fine to terminate somebody who tests positive, but we don't think it's right to deprive them of their right to unemployment because that would be a penalty. So as a result, those costs ultimately result in your contribution rates being increased if those claims are allowed. Okay, other indirect costs that employers are going to run into would be in the area of workers' compensation. So as you know, Ohio is one of a very few small number of states that still have a state monopoly, ironically, where we pay premiums to the Bureau of Workers' Compensation to administer claims. So we don't have insurance companies handling our claims. Those of you who might have operations elsewhere are probably very familiar with the insured system. In states like Louisiana, California, and New Mexico, where there is an insurance mechanism, the courts that have heard the appeals of workers' comp claims have said, well, if the medical marijuana prescription was a necessary medical expense, it's going to be allowed as part of the claim, which in other words means that it's going to be, the cost will be passed on to the employer through increased premiums. So one more thing to be concerned about. This one is, I think, self-evident. There's a lot of indication that productivity goes down when people are abusing any type of drugs in the workplace, and obviously accidents will increase as well. Disability issues. Very quickly, I want to cover these 3 cases. These cases do not involve necessarily unlawful substances. They involve a variety of substances that were tested for in this workplace. This Dura Auto Systems manufactures car parts. Initially, the first suit came out when the EEOC sued them under an Americans with Disabilities Act claim and fined them $750,000 for questioning employees who had tested positive for controlled substances. This was a little bit unusual. Not only did the employer question the employees, but it humiliated them publicly in front of other employees by trying to make examples of them, which is what set the second case in motion. The second case was brought by a group of individuals, and a number of them did get a jury verdict, basically saying that they were treated as having a perceived disability, regardless of whether they had a disability. Under the Americans with Disabilities Act, this is one of the 3 prongs that really can get employers in trouble, perceived disability. That case has actually been sent back to the lower court for the narrow purpose of looking at whether a drug screen constitutes a medical exam or just a disability inquiry. And in the third case, Wells versus Cincinnati Children's Hospital Medical Center, this was a very interesting case. A woman was acting very erratically, was just loopy and completely not herself. She was sent out for an evaluation. The physician who tested her said, yeah, she really shouldn't be at work. She was, I believe, a phlebotomist. And so the employer said, well, thanks, doc, but we're going to try to find an accommodation for her. They put her in another job for an extended period of time. She wasn't particularly doing a great job there. They ultimately terminated her, and then she brought a claim under the Americans with Disabilities Act and the Family and Medical Leave Act. The employer's basis for the termination was that she presented a risk of harm to herself or to others, the so-called direct threat defense that's available under the ADA. Unfortunately, the court said, be very careful, employer. We don't like employers using that just based on their own assessment of what somebody could or couldn't do in the workplace. Now, keep in mind, drug testing is lawful. There's no problem whether you live in a state that has marijuana legalization or not, but it doesn't tell you that the person is impaired. It just tells you whether they have the presence of drugs or alcohol in their system. Moving on, one of the other potholes, if you will, that I foresee is whether your employment practices liability insurance will cover claims that may involve the use of medical marijuana and the subsequent termination by an employer. So this is going to be an area that continues to evolve. Carriers have different requirements. Any of you who have had multiple carriers over the years know that they vary greatly. And not only the policies, but the requirements from one state to the other. One thing I would urge all of you to do is to go back to your workplaces and look at your job descriptions and really focus on any positions that have safety-sensitive components to them and to identify those safety-sensitive aspects. Another item to be careful about, and this is a little tidbit out of Colorado. The second fastest growing industry besides pot in Colorado is the private security business. Because as I talked about earlier, we're talking about a cash business. These are employees whose retail stores get held up. These are employees who have to drop off cash at the end of the day in the deposit and so forth. So something to be careful about, because, let me go to this slide, the last of the items that I listed here is the OSHA General Duties Clause, which requires all workplaces to very simply maintain a safe working environment for their employees. That's the extent of the general duties or catch-all clause for OSHA. Obviously, there are other federal statutes. We talked about the Controlled Substances Act, the Drug-Free Workplace Act, for those of you who are either federal entities or federal contractors, and it doesn't take much of a dollar threshold to be a federal contractor. And then those of you who are in regulated industries that have pilots, drivers, and other safety-sensitive positions, you'd be subject to the Omnibus Transportation Employee Testing Act. Okay, one thing I want you to just kind of take note of, those entities that are subject to these testing requirements, there are criminal sanctions for not complying with the testing programs. So just because a state law may say one thing, the federal obligation that you have remains in place, and the consequences are pretty severe.